All three of these families and the friends of these families are suffering, and all of their lives have been irrevocably changed because of the actions of the defendant. The unintended and collateral consequences of a selfish, intentional, and cruel decision by Mackenzie will ripple forever in time.
August 21st, 2023. A Cleveland courtroom sits in tense silence. Three families are gathered, united in grief but divided by blame. At the defense table sits 19-year-old Mackenzie Shirilla, her face pale, expressionless. Just days earlier, she was convicted of 12 felony counts, including 4 counts of murder. Not vehicular manslaughter, not reckless homicide, murder.
2 young men are dead. Their deaths were horrible, terrifying, and tragic. I will say again, if any reasonable person reviews Exhibit 802, there can be no doubt in your mind what happened this night. There can be no doubt of the absolute terror of the 2 people in that car.
On July 31st, 2022, at approximately 5:34 in the morning, Shirilla's 2018 Toyota Camry slammed into a brick wall at over 100 miles per hour in Strongsville, Ohio. The impact was so violent it split the car in half. Her boyfriend, 20-year-old Dominic Russo, was in the front passenger seat. His friend, 19-year-old Davion Flanagan, was in the back. Both were pronounced dead at the scene. But here's what made this case unlike any other vehicular death. Surveillance footage showed Shirilla never hit the brakes. Her foot remained pressed on the accelerator. The car's event data recorder confirmed she maintained full acceleration until impact. And 3 days before the crash, GPS data showed she had driven to the same location, leading prosecutors to argue she had scouted the site. The judge would later call her literal hell on wheels and describe the crash as premeditated. But Shirilla maintained she blacked out and remembered nothing. So what really happened in those final moments? Was this a calculated double murder or a tragic accident involving a teenage girl with a medical condition? This is the story of Mackenzie Shirilla. On the night of July 30th, 2022, 3 teenagers attended a graduation party at a friend's house around 10:15 p.m. They later moved to another gathering where they listened to music and smoked marijuana until approximately 5:30 a.m. on July 31st. Witnesses described the group as appearing normal and amicable before they left. There were no visible arguments, no signs of distress. They got into Mackenzie's Toyota Camry around 5:30 in the morning. Mackenzie was behind the wheel. No one could have predicted what would happen 4 minutes later. At approximately 5:34 a.m., near the intersection of Progress Drive and Alameda Drive in Strongsville, a surveillance camera captured the Toyota Camry turning onto Progress Drive. Watch carefully. The vehicle initially moves at a controlled speed. Then, suddenly, it accelerates, rapidly. The car races down the empty industrial road, reaching over 100 miles per hour in seconds.
There can be no doubt of the absolute terror of the 2 people in that car. The defendant controlled all the events. She chose the day.
What happens next is critical. The car maintains full acceleration without any braking. It makes a controlled hard right turn, drives through a business sign, and slams directly into the brick wall of the Plidco building. The impact split the car in half. All airbags deployed. When first responders arrived around 6:15 a.m., they found all 3 occupants unconscious and not breathing. Inside the wreckage, investigators made a disturbing discovery. Mackenzie Shirilla's fuzzy Prada slipper was found stuck on the accelerator. Her foot was still pressing it down. Dominic Russo and Davion Flanagan were declared dead at the scene. Mackenzie was airlifted to Metro Health Hospital in Cleveland with severe injuries requiring multiple surgeries. She would survive. Police also found psilocybin mushrooms and a digital scale in her possession at the scene. At first, investigators considered this might be a tragic accident, perhaps a medical emergency, maybe a vehicle malfunction, possibly even a momentary distraction. But as the investigation deepened, that theory began to fall apart. Mackenzie Shirilla told investigators she blacked out and had no memory of the crash. It was a claim that would become central to her defense, but the physical evidence told a different story. Forensic analysis of the car's event data recorder showed constant full acceleration, no braking, and deliberate steering adjustments toward the wall. This wasn't someone who had passed out and lost control. This was controlled, intentional.
There was no medical condition that caused this as an accident. There was no mechanical failure of the car. The record is clear on the facts and the evidence.
Mechanical experts confirmed the brakes and pedals were functional with no defects. The car was in perfect working order. Medical evaluations ruled out immediate neurological or musculature issues at the time of the crash. But perhaps the most damning piece of evidence was the GPS data. 3 days before the crash, on July 28th, Mackenzie's car had been at the exact same location,
Specifically, she chose a date just before her 18th birthday. She chose to drive the car, the time to drive the car. She chose an obscure, previously scouted route through an industrial parkway.
The crash occurred in the early morning hours on a quiet route with minimal witnesses. If you wanted to stage something without being seen, this would be the time and place to do it. And then there was her behavior after the crash. While recovering in the hospital, Mackenzie Shirilla's social media activity raised red flags. She posted TikTok videos from the hospital showing herself at concerts and making light of drug use. For investigators and the victims' families, it seemed to show a stunning lack of remorse. But it was a Halloween photo that truly shocked people. Mackenzie posted photos depicting Russo and Flanagan as corpses. When Flanagan's sister saw these images, she immediately alerted police. As investigators dug deeper into the relationship between Mackenzie and Dominic, a troubling pattern emerged. According to multiple witnesses, including Russo's mother Christine, Mackenzie and Dominic's relationship was turbulent and toxic. Christine reported ongoing conflicts and allegations of physical abuse by Shirilla. In July 2022, just weeks before the crash, there was an incident where Shirilla allegedly threatened to crash the car during an argument. Combined with witness testimony about the prior threats to crash the car, investigators began to see a pattern. This wasn't grief or trauma, manifesting in unusual ways. This looked like someone who had gotten exactly what she wanted. On November 4th, 2022, Mackenzie Shirilla was arrested shortly after her discharge from the hospital. Bodycam footage released in 2025 showed Shirilla crying as officers handcuffed her. In the back of the police cruiser, however, she appeared calm. She was initially charged with 17 counts, including 2 counts of aggravated murder and drug trafficking. The case was transferred from juvenile to adult court after a probable cause finding. For Dominic Russo's mother, Christine, and Davion Flanagan's family, the arrest brought some measure of relief. But the hardest part was still ahead, proving in court that this was murder, not an accident. In August 2023, Mackenzie Shirilla waived her right to a jury trial, opting instead for a bench trial before Cuyahoga County Judge Nancy Margaret Russo. The prosecution's case was methodical and damning. They presented the CCTV footage and event data, recorder evidence showing deliberate acceleration and steering. The surveillance video became Exhibit 802, a piece of evidence so crucial that the judge would reference it repeatedly.
The review of the evidence supports the factual findings, the forensic testimony, the testimony of the first responders, the testimony of the emergency room doctors who treated the defendant, the testimony of the coroner's medical examiner, the testimony of those who knew the victims and the defendant, and the testimony of the BMV official who provided evidence that not only did the defendant deny any medical condition when applying for her license, which her mother co-signed and attested to, but also that just after the accident, Mackenzie renewed her driver's license and again denied any medical condition. In fact, the defendant was so concerned about driving that, as the state mentioned during the investigation, she asked if they could just suspend her license for 10 years. It is hard to fathom how a person could be concerned about their driving privileges, having just been responsible for the deaths of 2 people.
The prosecution brought forward forensic experts who testified about the event data recorder. The data was irrefutable. Constant acceleration, no braking, controlled steering. First responders described the horrific scene they encountered. A car split in two, 2 young men dead, and Mackenzie with her foot still on the accelerator pedal, her slipper stuck beneath it. Emergency room doctors who treated Mackenzie testified about her condition immediately after the crash. The coroner's medical examiner walked through the devastating injuries that killed Dominic and Davion, but perhaps most striking was the testimony from the BMV official. When Mackenzie applied for her driver's license, she denied having any medical condition. Her mother, Natalie, co-signed the application, attesting to this fact. And, remarkably, after the crash, Mackenzie renewed her driver's license and again denied any medical condition. During the investigation, she even asked if they could just suspend her license for 10 years. A statement prosecutors argued revealed her consciousness of guilt and understanding that she was responsible. Witness testimony established the toxic relationship and prior threats to crash the car. Multiple people close to the couple described ongoing conflicts, physical altercations, and Mackenzie's disturbing statements about using the car as a weapon. The prosecution also presented Shirilla's social media posts indicating lack of remorse, the dancing videos, the satirical drug references, the Halloween photos depicting the victims as corpses. And crucially, they presented the GPS data showing prior visits to the crash site 3 days before the fatal collision.
She chose the target to hit and the victims. She She chose the means and the method to follow through. And she planned and purposefully executed the events of July 31st, 2022.
The defense, however, painted a different picture. They argued this was a tragic accident, not murder. They suggested the crash could have been due to distraction, impairment from marijuana, or a medical episode related to Shirilla's diagnosed condition. Postural orthostatic tachycardia syndrome, or POTS, a condition that can cause blackouts and loss of consciousness. They challenged the admission of prior acts evidence, calling it prejudicial. They tried to introduce text messages showing what they argued was an amicable relationship between Mackenzie and Dominic. Messages where Dominic appeared to be apologizing, suggesting he may have been the aggressor in some disputes. The defense pointed out that Mackenzie had no criminal record, that she was only 17 at the time. They argued that the crash was reckless, yes, but that recklessness did not equal intentional murder. They maintained that Mackenzie blacked out behind the wheel and had no memory of the crash, consistent with a POTS episode, but the judge wasn't convinced. On August 14, 2023, Judge Russo delivered her verdict. The judge found Mackenzie Shirilla guilty on 12 felony counts, 4 counts of murder, 4 counts of felonious assault, 2 counts of aggravated vehicular homicide, 1 count of drug possession, and 1 count of possessing criminal tools.
Her mother's uncorroborated statements without any medical testimony or records is not persuasive. It is also important to remember that even if Mackenzie intended to also die in this crash, that is irrelevant. A failed suicide attempt is not a defense to murder.
The judge was clear. Even if Mackenzie had intended to die alongside Dominic and Davion, it didn't change the fact that she murdered them.
And even in a murder-suicide attempt, when the perpetrator executing the plan survives, the other death or deaths are still murder. There's only one person who's responsible for the pain of everyone in this room, and that person is you, Mackenzie. Nobody else is responsible.
The judge described Shirilla as hell on wheels and affirmed the crash was premeditated. Not reckless, not accidental. Premeditated murder. The courtroom erupted in emotion, relief from the victims' families, devastation from Mackenzie's supporters. The case would now move to sentencing. On August 21, 2023, the courtroom reconvened for sentencing. It would be one of the most emotional hearings in recent Cuyahoga County history. Before the sentence could be handed down, the families of the victims would have their chance to speak, to tell the court who Dominic Russo and Davion Flanagan really were, and what their deaths had stolen from the world.
Today is an emotional and stressful day for 3 families, and for the defendant, and for those who care for Davion, Dominic, and Mackenzie. I expect everyone here to be respectful of everyone who's in the room, and if there is any disruptive behavior, I will pause the proceedings and the deputies will escort you out.
Judge Russo set the ground rules for what would be a profoundly difficult proceeding.
I will hear first from the state and the representatives of any of the victims. The court will then hear from the defense and any representatives who wish to speak. The defendant has a constitutional right not to speak.
The first to speak was Jamie Flanagan, Davion's mother.
Your Honor, my name is Jamie Flanagan. I am the mother of the victim, Davion Flanagan. I want to share a small part of what we lost on 7/31/2022. My son, Davion, is and always will be so much more than cargo. He was precious. He was an amazing soul with a heart of gold.
Davion Flanagan was 19 years old when he died, but his story began long before that tragic morning.
He gave to the world what he wanted most in his own life: love. The kind of love that would rescue a friend in the middle of the night, no questions asked. The kind that would protect others and honor them. He made friends easily with his infectious smile. He was a gifted athlete. He had plans to go to barber school and open his own shop. My son did not have a clique of friends, but instead was a friend to all. He would go out of his way to show love and kindness to others, including those that were often cast aside by society, the less fortunate, the developmentally challenged, the hurting, and the unvalued. Davion made sure that everyone that crossed his path knew that he truly saw them, that he valued them, and that they were worth his time. Davion and my kids have had more than their fair share of heartbreak, of hardship, and of loss. Davion was adopted. with his sisters from foster care. They are biological siblings. We are honored to be chosen, or to have been chosen, to be their parents. They're forever family.
Davion was an adopted high school athlete aspiring to become a barber. He and his biological sisters had been through the foster care system together before finding their forever home with the Flanagan family. For his sisters, Davion wasn't just a brother, he was their protector, the one person who had been there from day one.
I am devastated by the loss of Davion. The world lost a truly special man. My girls lost their best friend, their protector, the one and only trusted family that has been by their side from day one. This alone, or he alone, understands the pain and loss that they have gone through and was always there for them. This fact alone breaks my heart for my girls, for my family. So many dreams shattered, a future stolen. We will never get to see the amazing man that he was surely to become. His life was precious. Like I said, he was so much more than cargo. I pray daily for strength and perseverance for myself and for my family. I also pray that Mackenzie will find true remorse in her heart and true repentance. We thank all of those that worked so hard to help us bring justice for our son.
His family would later establish the Davion Flanagan Memorial Scholarship in his honor. Then Davion's sister, Davion Flanagan, took the stand.
Hello, could you start with your name?
Hi, Your Honor. My name is Davion Flanagan. Davion was my older brother. The passing of Davion Markel Flanagan has been very difficult for me. We have gone through everything together since day one. Davion was a big brother to me and my younger sister, Delia. We all got adopted together in 2012. After Davion passed away, a lot of trauma and past pain has came into my life, causing it to be difficult to heal from this trauma.
The pain in the courtroom was palpable. Davion and her younger sister Delia had lost not just a brother, but the person who understood their shared trauma better than anyone else. The three siblings had survived the foster care system together, had been adopted together in 2012, and had built a new life together. Now that bond was forever broken, then Christine Russo, Dominic's mother, addressed the court. Dominic Russo was 20 years old, Mackenzie's on-and-off boyfriend of 4 years. By all accounts, he was kind and outgoing, deeply connected to his family. Christine had watched her son struggle in his relationship with Mackenzie, had seen the toxicity, heard about the threats, witnessed the cycle of conflict and reconciliation. She spoke directly to Mackenzie, urging her to reflect on why she survived when the two young men did not. The defense would also have their say. Mackenzie's attorney attempted to contextualize her actions and plea for leniency.
You have a range of possibilities as it relates to a girl who was 17 at the time, who is now 19 years old and has no criminal record. And as you so correctly pointed out in the opening, the decision when she gets out is up to the parole board. And we know how the parole board operates, and we know that everybody gets flopped at least once. So a 15-year sentence becomes a 20-year sentence at minimum, and it'll be up to this young lady here as to how she's going to conduct herself for the next 20 years or whatever the sentence would be.
The defense attorney emphasized Mackenzie's youth, her lack of criminal history, and the reality that parole boards typically deny first applications.
Second of all, I'd like to say thank you so much for allowing and taking the time to read those letters. And I would like to concentrate on the letters from the people from juvenile court. First of all, Miss Smith and Miss Kent. They have been the people who have monitored her progress since she was entered the juvenile detention facility, where she was for about 9 months. I would like to commend them for writing these letters, because ultimately, or initially, I tried to have them send a letter and the people at juvenile court wouldn't let them. And so they sent these letters anyways. And what do we see from their letters? We actually see where both of them say that she expressed remorse during the time. They also both say that they have observed her grow as a person, that she's taken every single class possible, both culinary and college, that she's actually been a model inmate, the letters say, and that she has exhibited what they call the highest level of behavior. They grade people 1, 2, 3, 4 the better your behavior, the higher the number. She has always received the highest number.
The defense attorney highlighted letters from juvenile detention staff who had monitored Mackenzie during her 9 months in custody. They described her as a model inmate who expressed remorse, took every available class, and consistently exhibited the highest level of behavior.
So really now I'm going to give you my observations, because I understand what you talked with Mackenzie's mother about acceptance of responsibility, etc. All I can tell you is that from the moment I met this young lady here, she expressed sorrow. And I would say during the course of this trial, in the initial emails and statements, she said, "I'm sorry for what you did." The prosecutor has said that she hasn't accepted responsibility. Well, as you remember, during the course of this trial, our defense was that it was a reckless homicide. That's taking responsibility for what she believes happened.
The defense attorney concluded by asking for concurrent sentences rather than consecutive, arguing that Mackenzie had expressed genuine remorse and posed no risk of reoffending.
So ultimately, another thing that you have to ask for is the likelihood of recidivism, etc. Based upon all of those things, I'd respectfully request that you run the sentences concurrently. Thank you.
Mackenzie's mother, Natalie Shirilla, also spoke, defending her daughter and maintaining the crash was accidental due to her POTS condition. The courtroom was divided, grief on all sides, but blame firmly placed on the young woman at the defense table. For the first time publicly, Mackenzie Shirilla addressed the court.
The families of Dom and Davion, I'm so deeply sorry. I hope one day you can see I would never let this happen or do it on purpose. I wish I could remember what happened, friends, and Dom was my soulmate. I wish I could take all your pain away, and I'm so sorry. And to my family, thank you for the support and all the love you guys give. Thank you for fighting with me. I love you all so much.
She spoke tearfully, expressing that she wished she could trade places with Dominic and Davion, but for prosecutors and the judge, it wasn't enough. The question of remorse had been central throughout the case. Her social media activity suggested callousness, but her attorneys and detention staff spoke of genuine sorrow. The judge would have to weigh all of it in determining the sentence.
Today is the sentencing of the defendant for the purposeful and intentional murders of Davion Flanagan and Dominic Russo. And in a way, it's the second time their families are gathered again to grieve. It's also a day when Mackenzie's family will grieve for the future of their daughter. All three of these families and the friends of these families are suffering.
Judge Russo began by acknowledging the impossible position she was in. 3 families sat before her, all suffering, all devastated, but only one person was responsible for that suffering.
Each of these counts are statutory sentences. Each is 15 years to life with parole eligibility after the base term is served, and with parole strictly within the discretion and jurisdiction of the Ohio Parole Board. Each of these counts stands separate and apart from each other, and they can be run either concurrently or consecutively. That is the only discretion permitted to the court in the sentencing today.
The judge explained the legal framework. For each murder conviction, the sentence was mandatory, 15 years to life. But she had discretion in one critical area, whether to run the sentences concurrently or consecutively. Concurrent would mean Mackenzie could be eligible for parole in 15 years. Consecutive would effectively double that time.
This isn't the fault of Dominic's family, or Davion's family, or your family. And I know that each of you have asked your questions to yourselves, what if? What if I had done this or that? The truth of it is, none of us can control the intentions of another. And when there is a purposeful intent to harm or kill someone, it is the perpetrator alone who bears the responsibility for the choice and the consequences and the harm that follows.
The judge addressed the guilt that families of victims often carry, the what-ifs that plague them in the aftermath of tragedy. But she was clear, Mackenzie alone was responsible for what happened.
The difficulty for sentencing today, honestly, is whether or not I believe you should get consecutive sentences. I'm troubled that should I give you a concurrent sentence, that people will believe that somehow I'm being disrespectful to one of the victims. And on the other hand, I have to weigh the punishment.
This was the heart of the judge's dilemma. A concurrent sentence might appear to minimize one victim's death, but consecutive sentences, 30 years to life, would be extraordinarily harsh for someone who was 17 at the time of the crime.
There's a very good likelihood, Mackenzie, that you will spend the rest of your life in prison. That won't be up to me. That will be up to the parole board, and that will be up to you to a great extent.
Judge Russo acknowledged a reality that Mackenzie's defense attorney had also noted. The Ohio Parole Board almost never grants parole on the first application. A 15-year sentence would likely become 20, 25, or more. And if Mackenzie failed to demonstrate genuine rehabilitation, genuine remorse, she might never get out.
I understand that the pain in this room wants me to impose the harshest sentence. But I don't believe that would be the appropriate sentence, because I do believe that Mackenzie will not be out in 15 years. So she's sentenced on count 2, the murder of Davion Flanagan, 15 years to life. She's sentenced on count 1, the murder of Dominic Russo, 15 years to life, to be served concurrent to each other with credit for time served. I'll waive fines, fees, and costs, and your appellate counsel will be assigned.
Judge Russo sentenced Mackenzie Shirilla to 2 concurrent life sentences with parole eligibility after 15 years, plus concurrent terms for other charges and a permanent driver's license suspension.
As to the driver's license suspension for counts 9 and 10, the aggravated vehicular homicides, her driver's license is suspended for life.
Mackenzie would never legally drive again. At 19 years old, she would not be eligible for parole until 2038, when she would be 34. Video from the courtroom shows Shirilla reacting relatively calmly as deputies handcuffed her and led her from the courtroom. The legal proceedings were concluded, but for everyone in that courtroom, the emotional proceedings were far from over. In September 2023, Shirilla's legal team filed an appeal, arguing insufficient evidence and evidentiary errors. They claimed the judge should not have allowed testimony about prior threats and that the evidence was purely circumstantial. But on September 26, 2024, the 8th District Court of Appeals upheld the conviction in a brief ruling. The appeals court cited sufficient circumstantial evidence of intent: the acceleration, the lack of braking, the prior threats, the GPS scouting. They rejected defense claims of medical emergencies or an amicable relationship as inconsistent with the forensic evidence. The court affirmed the admissibility of prior acts evidence for establishing motive and intent, not character. The conviction stood. Case closed. Or was it? In April 2025, a new legal team filed for post-conviction relief, alleging ineffective assistance of counsel. This time, they brought new medical evidence to the table. They introduced an affidavit from neurologist Dr. Kamal Chamali, who reviewed Mackenzie's post-crash medical data: elevated lactate levels, low oxygen, complete amnesia. Dr. Chamali concluded these findings were consistent with a seizure or loss of consciousness due to POTS, supported by a 2018 study on seizure-related crashes. The new legal team argued the original attorney failed to present a medical expert. POTS medical records or text messages they claim were exonerating. Text messages later introduced in post-conviction filings showed Russo apologizing multiple times in one exchange, suggesting he may have initiated or escalated some disputes in the relationship. In other words, ineffective counsel that denied Mackenzie a fair trial. Prosecutors immediately opposed the petition, calling the evidence speculative and noting the filing was 1 day late, potentially barring it on jurisdictional grounds. As of mid-2025, Judge Russo is reviewing the petition, with a possible hearing on the horizon. Shirilla's family continues to maintain the crash was accidental. Mackenzie Shirilla remains incarcerated at the Ohio Reformatory for Women with parole eligibility in 2038. The courts have answered that question. But as the case continues to unfold, with new evidence and ongoing appeals, the final chapter of this story has yet to be written.